Good morning, everybody. My name is David Postolski, and welcome to the Intellectual Property Workshop of Veterans Launching Ventures. First, I want to just say thank you to Sakti for organizing this. No, we can't. Last time I did this, we were all in the same room. I know that's harder and harder these days, so hope you're all safe and healthy and enjoying the online virtualness of your educational experience with the program. I am I'm recording this from Tel Aviv, Israel, where I split my time. I have a home here and a home in New Jersey where my office is. I am a partner at a law firm called Gerhardt Law in Summit, New Jersey. We have offices in New York and Philly as well. Sorry, I just kind of put water on my hair. So we were an intellectual property boutique, which means we deal with how to educate and empower and protect all sorts of different clients, mostly inventors, creators, small companies, entrepreneurs, startups, large companies that want to be treated like a small company and kind of protect their value, what their intellectual property is, whether it's a patent or trademark or copyright or a trade secret. So this presentation is going to be short and sweet, but if there's anything more that you want me to get into, just let me know. I am going to share my screen and have some slides up. I might go through them a little bit quickly due to the time, but I'm going to give them to Sakti so she can share with you. And if you have any questions, you can feel free to contact me. I'm pretty public. My email will be on the slides, and I'm happy to answer any questions. Anyway, welcome to the workshop, and let's begin. So hang on, let me just share my screen to the presentation. I'm going to put it in presenter mode. Awesome. So, as you can see, I prepared this just a month ago. It said April 2020, but but I think right now you'll probably be seeing it in May or June, or it doesn't matter. This information is timeless. Case in point, the Constitution of the United States. We are the oldest intellectual property regime in the world. Every other country in the world has followed the intellectual property laws and regimes and structure as the United States. So if you understand the way the United States works, then you understand how most countries work. And the United States was built on intellectual property. It is the only fundamental right that is mentioned in our Constitution, right? We have the Bill of Rights, we have our amendments, but I'm talking about the actual Constitution written in 1789 by George Washington, James Madison, Thomas Jefferson, the forefathers of our country. They knew that when they were going to be building a new nation out of, the depths of the American Revolution, right, us breaking off from England, our founding forefathers said, let's write a constitution where we let people know that if they share their ideas with us, if they have ideas they have inventions, or they're authors, they have writings, they have discoveries, if they share it with us and give us that, and then we will grant them the fundamental right of intellectual property. And so this clause in front of you is called the Intellectual Property Clause. It says Congress has the power to promote the progress of science and useful arts by securing for limited time to authors the nod to copyright, and inventors the nod to patents, the exclusive right to their respective writings, again, the nod to copyright, and discoveries, and the nod to patents. So this is what our patent system was built on. It's over 250 years old, and as you can imagine, what is patentable and what is copyrightable has changed over the last 250 years as the American industrialization and technology continue to boom. But I put this up there to let you know that it is a deal you make with the government. In exchange for letting the government know what your intellectual property is, you will have the monopoly on that idea or on that invention or on that writing or on that brand or logo for an exclusive amount of time. So it's huge protection. It's federal protection. And so So just put this up there to let you know. Also, Commerce Clause, which is the grandfather of trademark law as well, right? If you have a brand or a logo, you probably want to experience commerce, right? The buying and selling of goods and services. So this is the earliest we know, the earliest mention also in our Constitution of the precursor to trademark law. So ultimately, what are we talking about here today? We're talking about intellectual property, right? Taking an idea out of your head and physically embodying it in something, whether that something is a patent or a trademark or a copyright or a trade secret. The only way to stop someone from doing what you're doing, from creating what you're creating, from making what you're making, from selling what you're selling, is to have the registered patent, trademark, or copyright in a particular country. It is the only way, right? There's no other way to stop someone. Why? Because that federal right, once you get it, once you work with a patent attorney, a trademark attorney, or a copyright attorney, then they're able to argue for the uniqueness, the novelty, the distinction, the creativity of what you've created. And in exchange, you get this federal right, which allows you to go into a court of law and say, hey, this is my federal patent. This is my federal trademark. This is my federal copyright. I believe that somebody is infringing me. And whether that somebody is doing it intentionally or not, you have the ability to stop them in a court of law. So it's like a golden ticket to the courts. And it's a really powerful stick to stop others from doing what you're doing. So that's the classic definition of intellectual property. But again, as a reminder, ideas in of themselves, not protected. Everybody has great ideas, but you physically have to do something with it. You have to, see a patent attorney and, describe its technical application. You have to create the brand or the logo for the product that you want to sell and get a trademark. You want to take that song or record that song or write down that song and, get a copyright on it. Without these things, without filing these things, the world will never know that you've created something. So, or courts will never know, and governments will never know, and other people will never know. So these rights are the most public expressions of your intellectual property, of your inventions, of your ideas, of your creativity. So think about that. I know all of you are working on something. Some ideas may get patents, some ideas may get trademarks, some may get patents and trademarks, some ideas may not be patentable, some ideas may just have good brands and trademarkable. There's all sorts of different ways to kind of cut this. I definitely have clients that fit all three, all the patent, the trademark, and copyright. There is a stepchild of the intellectual property regime, and that is the trade secret. Like I said, it is a choice you make as an entrepreneur to actually go on record and describe what the most public expression of your idea is in order to get a patent on it. But you don't have to take that deal. And again, that deal being that you tell the government when it is, and if you're awarded a patent, then you get the exclusive monopoly over it for 20 years if it's a patent. But you don't have to do that. You can do what Coca-Cola has done or what Google has done for some of their inventions, and they've chose to keep it a trade secret. What's a trade secret? Exactly something that gives you a competitive advantage, your client list, confidential information, the secret sauce to KFC or kind of like what goes on a Big Mac or WD-40, right? These are all kind of, well-documented trade secrets, meaning nobody knows what's in them, but the company itself does and has guarded it with their life. They have really kept it a trade secret. They have locked it down. They have all their employees sign non-disclosure agreements. There's no break in the chain of confidentiality or break in the chain of the trade secret. But the flip side is, right, patent or trade secret. Patent, most public expression. Trademark, nobody knows it. Patent, lasts 20 years. Trade secret could potentially last more, right? Coca-Cola has it for 100 years. Google search algorithm has it for 25. A patent costs a few $1,000s to register your patent in a particular country. Trade secret, there's no registration process, right? Patent, you have the ability to stop others that intentionally or unintentionally are doing something that fits within the definition of that public patent. That's gold. Trade secret, no, there's nothing you can do. If you call me up and say, well, we have this awesome trade secret and there's another company that's reverse engineering it And our first question to you is, well, did they steal it from you? Well, no, there's no evidence of that. Well, then they can reverse engineer. Trade secret doesn't allow you to stop anyone from doing anything similar to you. Only the patent does that. The protection you get for trade secret is if somebody in your chain or somebody in your organization or somebody in your supply chain misappropriates the trade secret, steals the trade secret, then you can go into a court of law and try to stop them from revealing it. But short of the evidence of misappropriation, there's nothing you can do, right? It's why we have the cola wars, right? Why there's, Coke and Pepsi and RC and all sorts of different things. Why there's the Google search algorithm and the Bing algorithm and the Yahoo search algorithm. Like there's all these different types of, ways to search, right? It's why we have, WD-40 and we have other sort of kind of like, get the squeak out of your oil type of, get the squeak out of your product by putting some sort of oil on it. So it's great protection, but it is limited. And the same thing with the patent. It's awesome protection, but it also is limited, right? You only have 20 years to really do everything that you need to do with that patent. 20 years is a long time, don't get me wrong, but it is a limited time. Trade secret can last forever. As far as the relevant costs, I mean, I kind of think, I often say, how much does it cost to keep something secret? Well, a lot of money these days, right? Encryption, agreements, so almost the costs might be actually similar. I think the ultimate thing that you have to ask yourself as a company is, do you really have something that's patentable, right? Is it truly novel? How do you determine that? You do a patent search. You do a worldwide patent search to see if anybody else has filed for something very similar. And, we can do that. You can do that. A patent attorney should definitely do it for you to kind of understand where your protection starts and where it begins. But, ultimately not searching for trade secrets, right? Because there's no publicness about them. But for patents, if after a search you truly have something novel, unique, and it's based in science, like it's based in mechanics or electrics, design, computers, physics, bio, chem, botany, whatever, then you likely should go the patent route. This world is definitely built around patents. We have about almost 11 million in our country, 2-3 times that in China. So I think the commercial world is definitely about the licensing and protection of patents. So, different types of patents. You can get a patent on the way something looks. It's called a design patent. It's up on your screen. But you can also get a patent on the way something works, right? You think about the iPhone, patents on design patents on how it looks, rounded edges, but also many patents on how the phone works, the different functions and kind of, the different features of the iPhone. Both, I definitely have clients that do both, right? If they have something truly unique from a utilitarian perspective, like from a usefulness perspective, it has structure and, not just design, it has features and functionalities and mechanics and parts and pieces, then yeah, we definitely try to protect it in both ways, utility and design. You can protect the way a plant is. I'm just putting it out there in this world of cannabis. Also an exciting area to be a part of that I do a lot of work in. But ultimately, these are the reasons why you get a patent. It's property after all, right? I mean, all intellectual property, not just patent. Patent, trademark, copyright is all intangible intellectual property, and thus, like property, it can be sold, it can be improved, it could be rented, which what we call licensing. You can use it as collateral for a loan, right? The same way you get you refinance your house or you get a line of credit. Same thing with patents, right? Investors love that stuff, right? They look at your patent portfolio, they look at your intellectual property portfolio, and they offer you money, right? In exchange for the assuredness that that investor is really investing in something that has been stamped by the patent office or the trademark office as yours and only yours, and you have an exclusive monopoly on it. But ultimately, it's the fifth one, the right to exclude someone else from making, selling, offering to sell, or importing your patent, that has the biggest weight, right? When you invent and file in the United States borders are your protection. We live in a territorial system. So if anybody tries to sell in the United States something infringing or bring into the United States something infringing, then you have the ability to literally stop them at the border through U.S. Customs if it's a product, If it's a service, you go into a court, and because you have the patent, right? So that patent holds, like I said, the golden ticket to kind of, to enact all of these additional follow-on procedures that allow others from kind of staying out of your space. The patent is the most amazing barrier of entry for a particular market. But it is just the United States. Like I said, we're a territorial system. So if you want a patent in China, you want a patent in Korea, you want a patent in Mexico, then you'll have a very limited time from when you first filed your application in the United States to take that filing and go into another country. It's something you affirmatively have to do. If you do not do it, then you will not have a patent in that country. You will not have the access to the courts in that country to stop someone else from doing what you're doing. So it's a really, really important protection, and you should, meaning international protection is a really important part to the process, and it costs. Like if you're going to spend, $5,000-$6,000 on a patent in the United States, you're probably going to spend at least that in another country. So and then if you think about all the countries you want to file in, it's a hard decision, right? It's a hard decision for any company, big or small, startup or large company, right? So you really have to think about where's your market, where are your infringers, where are you importing to, where are you exporting to? It's definitely something you should discuss with your patent attorney. Probably the biggest take home I want you to tell about patents before we move on to trademarks is this slide. The patent laws in our country have changed since 1790, that constitutional clause that we talked about. So it used to be that if you invented something but you never filed your patent, you maybe were waiting or something, that if somebody else filed the patent after you, if you were able to prove that you invented it before them, then you would get a superior right. Kind of makes sense, right? It was called what we call the first to invent country. It's no longer like that. In our country, it is a race to the patent office. If you've invented something and then never filed for your patent, and then somebody else invents and files their patent after you, then guess what? You can no longer say, hey, I invented that first. The person who invented and patented and filed their patent application first wins. So it's called we are now in a system like every other country. It is the first inventor to file. So what does that mean? It means if you have a really awesome idea and you have a really awesome invention, you can't wait around. You gotta race to the patent office and get yourself on file, because if somebody has filed their patent at least one day before you, then they will be first inventor to file, and they will have the superior right and be able to stop your invention from becoming patented or commercialized in this world. It's huge. It's a huge change in our law. It's been around for the last 7 years. And so, there's a lot of, interesting, complicated scenarios that come out as a result of that. I'm not going to get into it now, but I will tell you that for those of you that have been sharing your ideas, that have been making them public, that have been trying to sell a product and, maybe try to, sell or, speak to people to try to get more money so that you can actually file for the patent, you need to know that a direct correlation to this new law is that if your invention is public or on sale or offered for sale, then you only have 1 year from the earliest date of that public disclosure, that sale or that offer to sale, to file a patent application in the United States. Period, no exceptions. And so what does public mean? It means telling anyone that is outside of a non-disclosure agreement, or telling anyone that is outside of the statutory privilege of confidentiality, which is, rabbis, priests, doctors, lawyers, psychiatrists. So you can tell those people, and that's not public, or your spouse also, right? There's the marital privilege. But you tell your children, you tell your best friends, you tell your classmates, that's public. Mark that date. Fast forward 1 year, that's the time that you have to file a patent application. Period, no exceptions. That's what this new law has triggered. A lot of people don't know that, but I'm telling you that now. If it's the last thing you learn from me, it's that. And besides the fact, if you have a really great idea, zip it, right? Don't tell anyone. Just tell essential people. Hopefully they're under NDA. And again, essential people should be under NDA. I want to make that very clear. But you should not share your ideas with anyone. If you filed for a patent first, great, scream it. tell who you want, right? Because the day that you file is the day of your invention. So keep that in mind. And that is the end of patents. As you can see, there's a lot more I haven't even talked about. But again, you will get these slides, and I promise to answer any questions. Let's talk copyright for a brief moment. Everything you see here is what is copyrightable: music, dance, website pages, photography, choreography, art, software, right? You actually hire someone to, like, do some development and programming for you. Well, the software code is just like somebody sitting down and writing a book, right? They both can be copyrighted. And what do you get for copyright? If you copyright something, you get the 5 rights that you see here. You get to control whether somebody copies exactly what you've copywritten, distributes it, takes a piece of it and makes another work, displays it, or performs it. So that's a lot. There's a lot going on there, right? Really, depending on the medium, it triggers a lot of different things, right? You think about a song. Well, if you own the copyright to the words, then you also own the copyright to the performance of those words, right? You also own the copyright to the display of those words, maybe in a music video, right? You also own the copyright to the chorus of those words. So if somebody takes them and makes a new, song out of it, well, then it might be copyright infringement. So copyright is great. It is definitely it's the cheapest of the intellectual properties, but probably the most contentious, because there is no examination of a copyright. A copyright has to be original. It has to be, you have to have created it first. But the Copyright Office gets, almost tens of millions copyrights a year. So nobody is looking to see whether you truly created something before somebody else created it and before somebody else's copyright. So, copyright is great, but if you're and you should protect your stuff as soon as you create it, to kind of put that line in the sand that that's your creation date. But it is definitely the most contentious, and most of the disputes relating around who created what first in terms of a song, music, programming usually happens in a court of law, as opposed to patents and trademarks, which are administered by the United States Patent and Trademark Office, and you file for a patent and trademark, and then it's examined, right? The patent examiner, the trademark examiner looks to see what else has been filed before you, and you're only going to get your patent or trademark if you pass that examination. So that is probably all I'm going to say about copyrights. Again, it's a very convoluted intellectual property. Some people say, oh, it's one of the easiest. It might be the easiest to get because you're just registering it, but the issues around it become contentious really fast. And there's no way to really search whether somebody has filed the copyright before you for something that you think you were the originator of or the creator of. So keep that in mind about copyrights. Let's talk about trademarks, right? You all know what trademarks are. Just think about all the different brands that you used this morning: Crest, Colgate, Listerine, drink Starbucks coffee, got Dunkin' Donuts, right? Put on your Nikes, right? These are brands that are distinctive in their words or logos or sounds or smells, that the moment you hear or see or read what the trademark is, you know instantly what they are selling, period. And again, think about that. Crest doesn't sell crests, they sell toothpaste. Nike doesn't sell Nikes, they sell sneakers. So they've managed to find words and take words and create new meanings for them. That is the symbol of a good trademark. So I'm going to go through kind of, some of you may have brands, happy to talk about them separately. I'm going to give you like the 6 or 7 basic tenets on how to get a trademark in the United States that is registerable, and that is strong, and that is distinctive. And the first one is this: your mark, your potential trademark, should not conflict with others. Don't choose a mark of a brand that has already been trademarked. Why? It likely will be cited against you. The trademark office is there to protect consumers, that there is not going to be confusion in the marketplace. And so if somebody comes along and creates mouses and they want to call it Google and file a trademark for mouses and call themselves Google, well, the trademark office can say, well, there already exists a Google. and they're not, and the trademark office is not citing Google against you because they're a multi-billion-dollar company. They're citing it against you because it's the simple fact there's already a Google on the trademark register. So how are you going to prove that you are different from them? You may be able to, right? But you're already starting behind the 8 ball. Find a word that doesn't conflict with others. I know that's hard, but there are basic rules about how that could be done, and they start on this next page. Again, basic tenet, trademarks should be distinctive. That means they need to fall into certain legal categories that the trademark office kind of labels your trademark. So this is the worst type of trademark. We call it generic. Your trademark should not be made up of generic words. The government is not going to give any one company the exclusive right to control, which is what a trademark is, the word hotels.com, right? Hotels belongs to everyone. Mattress belongs to everyone. The word tire belongs to everyone. So what does hotels.com do? They don't have a trademark in hotels.com. They have a trademark in their logo, red background, 2 hours above the O. So you can use a generic word, but you got to make sure there's a logo to it because you're not going to get protection over the word that's generic. Worst type of trademark. Second worst type of trademark is descriptive. If you have to explain what you are doing to a consumer or to an investor, and you use the words of the trademark in your description, again, behind the 8 ball, you do not want that. That means you're descriptive. You cannot describe what aqua leak detection does without using the words aqua, water, or leak, right? So what do they have to do? Again, add a logo. That's their protection. So logos are great, but if you want ownership over words, which are the most common types of trademarks, do not use generic words and do not use descriptive words. What you can do is use suggestive words, right? So you can take 2 words like air and bus. Air and bus, pretty generic, right? But air and bus are not descriptive, right? Planes don't fly in the air, right? Airbus is a plane company, and planes don't fly in the air. Planes are not buses, but they carry people. So if a consumer has to be like, hey, what do you do and what do you sell? That is the best type of trademark that you could manage. And so think, you can use a generic word, but don't use it in the generic way like hotels.com. So use it in a suggestive way. And this is what we call the third best type of trademark, but not the best, not the second best. This is the second best. It's what Apple does, right? Apple doesn't sell apples. Apple has created a new meaning for the word apple. Right now you think of Apple and very few people think of the fruit. They really think of the iPhone. They really think of Apple TV. They really think of iPods. And so if you can take a word and create an entirely new meaning to it that is not generic or descriptive, then boom, that is awesome protection. Add a logo if you want as well. Excellent. So, but the best type of trademark is what we call fanciful. Fanciful is basically a made-up name, right? It's Kodak doesn't mean anything. So if you can take 2 words, mash them together, the more ridiculous sounds, the better, right? Like, creating a brand new word, or, even taking a word like Google or Uber and like creating a totally different meaning to it, because they do have meanings, is also like in that fanciful, kind of a sphere. So if you can coin a term, then you will have the most ultimate protection. What do I mean by that? You'll probably spend a lot of money on developing it, right? Because you have to teach the public what your trademark means, but you will spend less money on how to enforce it, right? So if you have a generic word, you're not going to stop anyone from using it. So you're just going to fight, and use all your money. But if you had a fanciful or arbitrary or suggestive word that nobody else has seen or nobody else is using in the same way, this includes logos as well, then you will spend less money trying to stop someone from using it, because you basically get the federal trademark registration and the most exclusive rights to it, which is the ability to stop someone. So that is trademarks. There's definitely a few other slides around trademarks, and again, we can talk about them, kind of separately. This is me. I've been an intellectual property attorney for about 17 years now. Again, I split my time between Israel, New York, and New Jersey. And I'm happy to talk to anybody on Zoom, audio, video. One day we can meet in person. And I wish you all tons of luck with your ventures. I admire what you're all doing, and I'm really happy to take any questions. And good luck with everything, and take care.